Martin Luther King, first time Martin Luther King came up in this courtroom, was out of the mountains, Mr. Schaefer, during his opening statement. That's reality. The term sexual harassment doesn't appear in that verb. Harassment based on gender. The only time sexual harassment appears is in that official duties instruction we talked about. Detective Craig. Yes, she did say that Ms. Fry told her that Benelia Sanchez Hunter told her about the kiss after she resigned. But what did she also tell you? It wasn't important to her at the time. She didn't ask. But then I pointed out, actually, that was the one time that she actually asked. Detective Craig came back to Donna Fry and says, in reference to the statement Donna Fry was talking about the professional comment. She was upset because she didn't want to be called unprofessional. Detective Craig asked Donna Fry, is that where she told you about the kiss? Her answer was no. Donna Fry told her, I asked her about that. Donna Fry told you to testify that she knew about the kiss before she resigned. Detective Craig was the only one brought in to counteract that. We met the burden of proof. The person that's more believable is Donna Fry, the one that wrote the letter on April 2nd, 2013, resigning. Suggestion about the radio. Both psychiatrists and psychologists both agreed that could have been therapeutic. We know from an email that was sent to Ms. Hasselhauer that Ms. McKenzie said, it's important to me. It was important to her. It was important to the city. Dr. Dario wanted to say, well, that's inconsistent with someone that is going to go into a shell. He was painting a black and white view. A person that wants to go into a shell and stay there, someone that doesn't go to the radio, doesn't talk to other people. Well, how about this more reasonable approach? How about a person that has a tendency to go into a shell, but struggles and fights against it? That's what happened. It was important to her, and she did it. What really fires me up, though, this idea that the city of San Diego, the crown jewel to work at, especially if you consider what Mr. Schaefer was saying about the city of San Diego. Because at the city of San Diego, apparently, when a mayor puts his arm on the top of your breast, that's not your breast. Apparently, at the city of San Diego, when the mayor harasses you and assaults you and batters you on your day off, he gets a free pass. That's not sexual harassment. What kind of message are they sending? Are you kidding me? You go into work on your day off and you take your kid in there and your boss puts his hands on your breast, gives you a hug, and you can't do anything about it. That's what Mr. Schaefer was saying. Absurd. The city of San Diego, if someone harasses you, you better make sure the first time you say anything, you reveal all details. Every single one, because if it's the slightest inconsistency, you will be nitpicked to death and accused of being a liar. That's what the city of San Diego says to its sexual harassment victims. By the way, had they bothered to talk to Ms. Sherritt, she would have told them the same thing. The claim. He said the first time that the mention of the buttocks was ever there was here in this courtroom. Well, how about the claim? Can you put that up? This is back 2013. He rubbed his body against hers. All along, it's been there. You know what? Mr. Schaefer, perhaps hasn't been listening. Just because a woman who's been assaulted doesn't come in and say, yeah, he put his penis area against my buttocks, and share all those details, doesn't mean that when she says he pulled his body into hers and the witnesses say he pulled his body into hers, doesn't mean she's not saying that. What you do is you say, I know this must be difficult for you, because it is. Tell me more. Tell me more about what happened. They didn't do that. And instead, they want to accuse her of being a liar. Now, guess what? They don't like the city of San Diego. If you talk to, if there are some witnesses of yours, especially your subordinates, and you really don't want to file this claim, better not go talk to them. And I think the reasonable interpretation of that would be ask them, hey, listen, Lori, Stephanie, you got to file this claim. They're going to talk to you. Just want to let you know that. Is that a reasonable thing to do? I think in the city of San Diego it is, because of the way they treated Lori Sherry. If you recall, at the end of her deposition, the questions asked by Mr. Schaefer related to, isn't it true that you're trying to get a letter of reference from her? What's he trying to insinuate? That Lori Sherry, the poster child of a reasonable woman, somehow making all this up because she wants a letter of reference? That's what this crown jewel treats witnesses like. Stephen Hadley, Donna Fry. If they say anything that's supportive of the victim, they're lying. You know, Kathy Ruiz, she heard about what happened. First thing she says, file a complaint. Karen Hassenhauer, she got on the stand, said the same thing. But what did she say? She said, I talked to Ms. McKenzie and I said, Stacy, you don't want this happening to other women, do you? This crown jewel, city of San Diego, says this can happen to a woman and there's nothing she can do about it if it happens to happen on her day off, even though it happens at the very park she manages. That is not a crown jewel. That is not the law. It is absurd. $1. After all this disaster brought on by that man, disaster, $1. If Ms. McKenzie was so unhappy, so devastated, that she couldn't come up with a single photograph, or maybe 5 or 10 or whatever, that she couldn't post something on Facebook where she was not smiling, if she was so that devastated, do you think we'd be asking for $150,000? We're being reasonable. $1? That's not reasonable. You know what that is? That's saying to you, City of San Diego, we can do whatever we want, and you can't do anything about it. The City of San Diego is saying, harassment like that? No big deal. That's what they're saying. And I'm asking you, don't bite on that. We're better than that. On behalf of Mr. Mitchell, Ms. McKenzie, Mr. Corrales, thank you for your time. This is important.
Thank you, Mr. Gillian, and thanks to counsel for both sides for the thoughtful and passionate arguments today and for the efficient manner in which the case was presented before this article. Ladies and gentlemen, let me first remind you that having heard testimony and the argument today that a witness in this trial has been convicted of a felony. You were told about the conviction. I remind you only to help you decide whether you should believe the witness. You must not consider the conviction for any other purpose. All right, ladies and gentlemen, in just a few minutes, I'm going to be sending you through that door and into the jury room. And the first thing you should do when you get there is choose a presiding juror. This is also known as the foreman or the foreperson of the jury. Regardless of the name, the job is the same. The presiding juror's duty is to see to it that your discussions are orderly and that everyone has a fair chance to be heard. Folks, it is your duty to talk with one another in the jury room and to consider the views of all of the other jurors. Each of you must decide the case for yourself, but only after you've considered the evidence with other members of the jury. As I've said, this is the great genius, one of the great geniuses of the jury system. Folks, you should feel free to change your mind if you are convinced that your position should be different. You should all try to agree, but don't give up your honest beliefs just because the others think differently. Folks, I'm going to make a request of you, and it is this. Don't state your opinions too strongly the minute you get into the jury room. Don't walk in there and immediately announce how you intend to vote. This is the group dynamics thing, okay? Doing something like that may interfere with your ability to have an open discussion. People who make a pronouncement maybe get their back up and they're resistant to change. You should keep an open mind so that you and your fellow jurors can easily share ideas about the case. Now, you should use your common sense and your life experience in deciding whether testimony is true and accurate. But during your deliberations, don't make any statements or provide any information to other jurors based on any special training or unique experience that each of you may have in matters related to this case. What you know or may have learned is not a part of the evidence that was offered in this case. And so there's a distinction there between life experience and common sense in deciding whether witnesses were telling the truth versus bringing in some specialized training or knowledge that each of you may have. Okay, please make that distinction. Now, sometimes jurors disagree about or have questions about the evidence or about what witnesses may have said in their testimony. If this happens, you may ask to have testimony read back to you. It's called a readback request, and I'll have a specific instruction for you in a moment about that. We are sending in addition to the binder that I held up yesterday, this binder with all of the received exhibits. You'll be able to look at those and study them during your deliberations. There are a few things that were provided to you electronically. If you want to see those again, that is the deposition and so forth, you can write me a note and ask to see that. If you want something along those lines or need further explanation about the law, you may write me a note on an otherwise blank sheet of your notebook paper, give it to our bailiff who will bring it to me. I will then discuss it and share it with the attorneys, all right? Because that may take some time to gather them from wherever they may be at that instant, you should continue your deliberations while you wait for my answer. I will do my best to answer any question you do send out. But importantly, folks, if you write me a note, don't tell me how you voted on any issue. Don't give me that information unless and until I ask for it right here in open court. Okay? Folks, at least 9 jurors must agree on a verdict. When you have finished filling out the verdict form, which I'll get back to in a moment, the presiding juror's job will be to date it and sign it and then give it to the bailiff who will actually just notify the bailiff and he will bring you into court. Folks, your decision must be based on your personal evaluation of the evidence presented during this case, and each of you may be asked here in open court how you voted on each question. So with regard to the special verdict form, there's only going to be one, and it's right here in this book, and it's marked with the yellow tag that I put on it. Sometimes jurors get in the jury room and they say, we want 11 more copies of the special verdict form. Okay, I don't do that. If you make that request, I will not grant it. There's just going to be one. I think if you think about, that kind of a request, you can see that much mischief could come from that kind of a request, and that's why I don't do it. So you're just going to have one original of the special verdict form, the one that will be the permanent record of the court. So that bespeaks two things. First, caution in completing number one, and number two, I want you to each keep notes of how you voted on each question, because then if you are asked here in open court how you voted, I want you to be able to respond accurately, okay? Now, I know you wouldn't do this. You've been very attentive and timely, jury, and I'm grateful for that. I know you wouldn't do this, but I am required to instruct you that you must not base your decision on chance, such as the flip of a coin. That works at the Super Bowl, but not here. Okay? If you decide to award damages, you must not agree in advance to simply add up the amounts that each juror thinks is right, and then without further deliberation make the average your verdict. You certainly may take breaks. You'll probably want to take one for lunch, but during any break, any recess in your deliberation, not discuss the case amongst yourselves or with anyone else. The only time you can talk about the case is when all 12 jurors are personally present in the jury room. Okay? I've seen some varying practices regarding note-taking. If you've taken notes during the trial, you can certainly take your notebooks into the jury room. Folks, please use your notes only to help you remember what happened during the trial. Your independent recollection of the evidence should govern your verdict. You should not allow yourself to be influenced by the notes of other jurors if those notes differ from what you recollect. At the end of the trial, as I told you at the outset, your notes will be taken out, torn out of the books, and destroyed. We'll recycle those books for the next jury. I told you a moment ago you have the right to request readback. You may request in writing that trial testimony be read to you. If you do so, I will have the court reporter come in to read the testimony to you. You are entitled to request that all or part of a witness's testimony be read. Now, if you make such a request, you should be as specific as possible. It would be helpful if you can state the name of the witness, the subject of the testimony you'd like to have read, and the name of the attorney or attorneys asking questions when the testimony is given. Now, if you make such a request, the court reporter is not permitted to speak with you when she's in the jury room with you reading back the testimony that you've requested. While she's in there reading the testimony, you may not deliberate, you may not discuss the case. You may not ask her to read testimony that was not specifically mentioned in a written request. And if there is a readback and your notes differ from the testimony that is read back, you must accept the court reporter's records as accurate. Okay, now I've told you about the special verdict form. It's here in the book. You saw it, or portions of it, during closing arguments. Both sides utilized it as they are entitled to do. Here it is. Here's the official original version that you'll be completing. As counsel indicated, it is about 7 or 8 pages in length. It has several questions on it that you must answer, and it is at the end of the book after the written version of my instructions. I've already given you the instructions on the law that you are to use in answering the questions on the special verdict form. You must follow my instructions and the form carefully. You have to consider each question on the special verdict form separately. Although you may discuss the evidence and the issues to be decided in any order that you want, You have to answer the questions on the special verdict form in the order in which they appear. The reason for that is after each question, there's an instruction that tells you what to do next. And what you do next may depend on your answer to the preceding question or a series of questions. Okay? As I've said, at least 9 of you must agree on an answer before you can move on to the next question. But it does not have to be the same 9 or more people on each question. Any 9 will do. All 12 of you must deliberate on and answer each question regardless of how you voted on a preceding question. Unless the verdict form tells all 12 jurors to stop and answer no further questions, every juror must deliberate on and vote on all of the remaining questions. Again, when you finish filling out the form, the presiding juror dates it and signs it at the bottom of the last page, notifies our bailiff that you are ready to present your verdict here in the courtroom. A word for our 4 alternates. I will actually have several things to speak to you about, but right now just this. The jury will soon begin its deliberations, but you're still alternates and you're still bound by all of my instructions and all of the admonitions that I've been given throughout the case. Until the jury is discharged, you must not talk about the case or the people involved in it or any subject involved in it with anyone, even family, friends, people living in your household, etc. Certainly not with each other. You must not have any contact with the parties and witnesses and lawyers or the remaining members of the panel. You must not decide how you would vote if you were deliberating. And the reason for that is if it sometimes comes to pass during the deliberations that a juror is unable to proceed via illness or some other reason. And if this happens, one of you will be inserted. By rule, if that occurs, the jury has to disregard all earlier discussions and start over. Okay? So you won't have missed anything. You must not form or express any opinions about the case unless and until you are substituted in for a sitting member of the panel. I told you a moment ago, folks, that you may be asked here in open court whether the vote on any particular question expresses your personal vote. That's called polling the jury. And this is done to ensure that at least 9 jurors have agreed on each decision. As I've indicated, the verdict form asks you to answer several questions. You have to vote separately on each question. So this is why I've asked you to keep careful notes of how you voted on each question. Okay? We did have one question from a juror during the trial. You were instructed to write out the question and provide it to me through our bailiff, which one of you did do. I shared your questions with the attorneys, after which it was my decision whether the question could be asked. If the question was asked and answered, you can consider the answer as you would any other evidence received in the trial. Don't give it any greater or lesser weight because it was initiated by a juror. If the question was asked, and my memory is it wasn't, please don't speculate as to what the answer might have been or why it was not asked. There may be many legal reasons why a suggested question could not be asked of a witness. Give the question no further consideration. During the trial, there have been several materials shown to you to help explain or place in context testimony or other evidence in the case. You're getting the materials that were received in evidence in that binder that I showed you a moment ago. You'll be able to review that, of course, during your deliberations. The other material that's not in the binder we refer to as demonstrative material or demonstrative evidence. It wasn't admitted into evidence, it was shown to you. You won't have that in the jury room. You won't be able to review those materials because they themselves are not proof of any facts in the case. However, you certainly can consider the evidence that was associated with or presented in connection with those materials. Now, there have been a few things shown to you or presented to you for your ears that are electronic in nature, and the equipment necessary to view or hear those materials will not be available to you in the hearing room. You'll see that it's somewhat Spartan, less so than it used to be. If you want to hear or see any of that material again, you need to write us a note. We'll bring you back here into the courtroom and play it or display it. The reason that we don't have any of the material in there, or any of the equipment rather in there, is because, again, you can't use the internet for any purpose during your deliberations, and we don't want people being tempted in that regard. Okay. Those then are the concluding instructions for you. Counsel, may it be stipulated that they received the exhibits, the jury instruction, the stipulation of the party, and the special verdict may go in the jury room at this time.
Yes, Your Honor. So stipulated.
Thank you. Ladies and gentlemen, during your deliberations, you will observe the following schedule. You will break at noon, come back at 1:30, be excused for the day at 4:30 until you reach a verdict, start again at 9 o'clock. Now, there's a glitch here. We're closed tomorrow. I remind you of that for Say-Star Shop as a day. So you will not be here tomorrow. You will be here Monday, 9 o'clock, to resume your deliberations and basically follow the schedule that we've been following. You're entitled to take breaks whenever you wish, but as I've said, during any break, don't discuss the case, don't deliberate. Only deliberate when all 12 jurors are present. Again, no tests, no experiments, no contacting anyone to assist you, no visiting the scene during the day off tomorrow, no internet research, nothing like that. In other words, all the admonitions continue to apply during your deliberation. All right, Madam Clerk, kindly swear in our day.
You solemnly state that you will keep this jury together in some quiet and convenient place, that you will permit no person to speak with them or communicate with them, nor will you speak with them yourself about this cause unless by order of the court, or to ask them if they have agreed upon a verdict, and you will return them into court when they have so agreed or when so ordered, so help you God.
Ready. All right, will counsel stipulate that the jurors may be released in the evening at noon, for any breaks, reconvene, and escorted into the jury room in the morning after the dinner recess by our bailiff, without your presence, that of your client, and that of the court.
So stipulated.
So stipulated, Your Honor.
Thank you. All right, ladies and gentlemen of the jury, not including the alternates for the present purposes, would you kindly rise, gather your notebooks, your personal belongings, and go with Deputy Bureau. All right, the record will reflect that the jurors have withdrawn, still present are the alternates. Ladies and gentlemen, in the old days, we used to send you down to the jury lounge and make you wait down there.